Hello and welcome to a fresh episode of Legal Wrangle on direct tax, where we will track major court decisions pronounced in the last few weeks. To keep you abreast with these developments, we have selected three important cases. One from the domain of territorial jurisdiction, second from the domain of penalty on delayed return filing, and third one from the domain of suo motu extension for submission of audit report.
The action of reopening or revisiting the already completed assessment on the opinion of escaped income is not new and has obviously been done again and again on the settled laws. However, the present case represents somewhat different situation. So let's understand what exactly happened in this case.
During the relevant year, Messrs. Rave Entertainment Private Limited Kanpur was amalgamated with the assessee, that is Messrs. Reliance Media Works Ltd Mumbai, and in the light of the amalgamation, Rave Entertainment Private Limited stood dissolved and its head office was shifted to Goregaon East Mumbai, as the assessee, that is successor company, was also based in Mumbai. The problem started when the assistant CIT Kanpur issued reopening notice to the assessee alleging escaped income, which was brought before the High Court on the ground of territorial jurisdiction. Now, let's see what the High Court finally decided.
The High Court admitted the fact that the present assessee was a regular assessee at Mumbai and was never assessed to tax at Kanpur. Therefore, ex facie, the income tax authorities at Kanpur had no territorial jurisdiction to issue any notice under Section 148 for reassessment of the assessee.
A similar controversy has been dealt with by the Supreme Court in Marshall Sons and Company Limited versus Income Tax Officer. The apex court in this case had observed that in case of amalgamation, assessment can always be made and is supposed to be made on the transferee company, taking into account the income of both the transferor and the transferee company. It means the assessment has to be made by the assessing authority of the transferee company, which happens to be the authority at Mumbai. Before we move to our next decision, let's quickly understand what the key takeaway was.
Income tax authorities have no territorial jurisdiction to issue reopening notice to a regular assessee of a different jurisdiction.
In our next case, the division bench was to decide the validity of suo motu extension of time by AO for submission of special audit report. The assessee's return for the assessment year in question was picked up for scrutiny and notice was issued under Section 143 subsection 2. Whereby the assessee was directed to get its accounts audited under Section 142 subsection 2A within a period of 35 days. Thereafter, several extensions were granted by the AO, as a result of which the special audit report was required to be furnished to the AO. The AO framed assessment ignoring the recommendations in the audit report and making certain additions to assessee's taxable income. When the matter reached the ITAT, the assessment was declared and barred by limitation in terms of Section 153 subsection 1. The ITAT further went on to hold that when no application was filed by the assessee seeking extension of time for submission of audit report, then the order of AO purportedly under Section 142 subsection 2C granting extension was not valid.
The final verdict of the High Court was, where the special audit report under Section 142 subsection 2C is not furnished within the time stipulated by the AO, extension of time can be granted by AO on an application made by the assessee. Suo motu extension of time period by AO for submission of audit report without having any such authority as per existing provisions of Section 142 subsection 2C is invalid.
Section 142, subsection 2A anticipates timely submission of special auditor's report. The auditor who is to conduct a special audit under Section 142, subsection 2 is not an auditor of the assessee's choice but was nominated by the revenue. In case special audit report is unable to be furnished within stipulated time, extension can be granted by the assessing officer upon assessee's application. From 1st of April 2008, a proviso to Section 142, subsection 2C was inserted to provide that the assessing officer may suo motu extend the period provided that the aggregate period originally fixed and extended would not exceed 180 days from the date on which a direction was first issued to the assessee for submission of special audit report. In the present case, even when there was no application by the assessee after a certain date for extension of time period for submission of audit report, assessing officer made an endorsement on the letter submitted by special auditor, extending the time for submission up to the date on which the auditor's report was actually received. In a similar controversy in the case of CIT versus Bishan Saroop Ramkishan Agro Private Limited, it was explained by this court that insertion of the expression suo motu in the proviso to section 142 subsection 2c was only with effect from the 1st of April 2008. Therefore, where the assessing officer on his own has extended the period of submission of audit report when he had no power to do so under section 142 subsection 2c, such an extension would be invalid.
Now let's move to our last case, where a trust was imposed with penalty for delayed filing of return. The SSE trust was served section 142 subsection 1 notice as it had failed to file its return. It filed nil return. During assessment, the AO determined the income by disallowing depreciation and imposed penalty. The SSE argued that there was no willful neglect in filing the return and disclosing correct particulars of income. When the matter was taken to ITAT, it was observed that SSE led no reliable material of substantiate his claim of depreciation. Also, no particulars of assets owned or eligible or depreciation allowances were brought on record to enable the tribunal to make inquiry as to how the explanation pertaining to availability of depreciation was bona fide or at least plausible. Thus, the levy of penalty was confirmed by the ITAT. Now let's see what High Court finally decided.
From perusal of the explanation tendered by the assessee, it became apparent that assessee's claim for depreciation was a debatable one. The assessee in the present case, only upon a bona fide belief about availability of depreciation, did not file return. This stand of assessee was ultimately vindicated in the case of CIT versus Krishi Upaj Mandi Samiti, where it was held that penalty under section 271 could have been imposed only if the assessee would have intentionally concealed the income in its returns or had given incorrect details of its expenditure as well as in the returns. In the case in hand, there is neither any concealment of particulars nor furnishing of inaccurate particulars of income. The assessee, only with a bona fide belief about allowable depreciation, had not filed its return. The explanation given by the assessee was also debatable, and ultimately that debate came to be decided in the favor of the assessee. As such, there was no sufficient reason to subject the assessee for a penalty under section 271.
Delayed filing of income tax return on account of bona fide belief is no ground for levy of penalty under section 271 subsection 1 subsection c.
With this, we wrap up this episode of Legal Wrangle. Please send in your suggestions at editor@tiol.in. Next time, we will bring some interesting cases from the world of excise and customs. Keep watching TIOL Tube for our upcoming education video series Learning Curve. Thank you for watching.